Hello and welcome to Legalese. I'm Ernie Hyde, your host, and Legalese is brought to you by the Northern Middlesex Bar Association on a monthly basis on subjects of interest to the general public on legal subjects. This particular series of shows, and there's going to be two of them, part one and part two, is going to be on small claims. And you would think that small claims would have been a 10-minute show and we would be done with it and have to make up time. But as it turns out, there's enough in small claims so that if we're going to get the point across to people who would use it, we really had to divide it up into two shows because of the time slots where it is carried in various stations. So we will break it up. Part one will be talking more about the procedures involved in small claims. So if you are thinking about going to small claims court, either on the plaintiff side or the defendant side, you might want to listen to this. And the second part of this will be more on the enforcement and appeals side of small claims. At any rate, I'm fortunate enough to have with me today Wendy A. Wilton, who is an attorney and also the Clerk Magistrate in Ayer District Court. Wendy is the person that you will typically, not always, but typically see in small claims as, frankly, the judge that determines the facts and makes the decision as to who wins or loses, or however the case does come out. I also have with me Francine Traiger Poor. Francine is in my office in Shirley, and she handles most of our collection cases, and as a result is in small claims on a regular basis, and knows an awful lot about how to file those claims and how to proceed with them. Welcome both.
Thank you, Ernie.
Let's talk about what the objective and the goal is of small claims. First of all, as I understand it and as I have perceived it over the years, it's a court designed to keep things simple, straightforward, prompt, very informal, typically. It's inexpensive overall if you compare it to civil court. The only real restriction on it, which has been enhanced over the years, is the limit of a claim that you're able to bring. You want to say something about where we're at?
Where we are at currently is a limit of 7,000, except there's one exception to that is property damage, motor vehicle property damage cases. There's no limit to that, although I don't think I've ever seen one in the 20 or 30,000s. It is, as you said, intended to be simple and informal. It is designed to address tort actions and contract actions. There is no slander or libel. And there are some types of cases that couldn't be in small claims because they're not within the jurisdiction of the district court. And the one that comes to mind is if you're suing a government official. The Mass Tort Claims Act would preclude you filing in a district court. You'd have to file in Superior Court. So there are some exceptions to the type of cases you can take in small claims, but essentially there's a 7,000 limit. The 7,000 limit is the base if you're going to sue for double damages or triple damages under, for instance, the Consumer Protection Law. You would start at something up to 7,000 and then it could be tripled. On the other hand, you can't split claims. You can't take a $14,000 case and split it into two claims. So it's basically 7,000 and tort or contract cases, and that's pretty much what we see.
Okay. Now, I know that you were on a committee in what, 2001, when you went over the rules, the committee went over the rules in small claims and made quite a few adjustments and made some studies, went through some tests. You want to explain those?
Well, it was a committee established by the Chief Justice of the courts, and my understanding is there had been some complaints or some issues raised about consistency throughout the courts, and at that time about the inability to collect. And I know we're going to talk about collection in another setting, but that was kind of the driving force for that committee. The committee included a judge was the chair, 2 or 3 clerk magistrates, attorney general representative, both sides of the bar, collection attorneys, and our original mission was to rewrite the standards, which we did, but out of rewriting the standard came some amendments to the rules. And the big thing that came out of that was the payment review hearing. I think before, and you folks know, that traditionally in a civil case, it's a 2-part procedure. You have to first sue somebody and obtain a judgment that says they owe you money. And then the court has certain jurisdiction to do things, and it's usually to adjudicate the case. But then if you get a judgment and you want to get that judgment satisfied, you have to, or you can, or may, use the courts again in what we call a supplementary process proceeding, where the court has different kinds of authority. So you have to refile a separate action and reserve and all of that. And so what small claims through the years has attempted to do is to put those 2 procedures together and make it simpler and quicker for folks. And prior to that committee, you actually had to, my memory is you would receive a judgment and the judgment wouldn't be paid, and then you'd have to notify us that it's not paid and file something called a notice show cause, and then we'd have to reserve them and bring them in, and there's expense to that. So
As a matter of fact, I think we had to reserve them.
It may be,
Isn't that true?
It's been a while. It's been a while.
Yeah, I know, even for me, but my recollection is that we had
In
to
any case, it's an
reserve them.
expense to you.
Yes, of course, which is an expense to the client.
It's an expense to you, and it's also an expense to the defendant who ultimately pays.
Right.
And it was more paper shuffling, and so the pilot was to look at a thing called a payment review, where we kind of skip all of that and we go directly to payment review. And so we're sending a notice of judgment, and we're also scheduling a payment review. So it's less expensive, it's quicker, you have a date, you don't have to tell us anything, the only thing you'd have to tell us is it's paid. So that was the largest thing that came out of that committee back then. And
Now, the review is 30 days.
30 days.
Typically.
Roughly.
And what takes place in the review?
The notice that both parties will receive will tell them that you can do one of several things. You can pay it. You can call the plaintiff or contact the plaintiff and work out a payment schedule outside of court. Or you can come to court and we'll work with you to work out a payment schedule. And we also include a blank short financial statement. And I want to be careful here because I believe it's a 1-page form. It's not an extension,
yes, it is,
but it captures enough information so that we know where we're headed. And the idea was that people could receive this, that defendants would receive this, fill it out, and then have a conversation, a meaningful conversation with the plaintiff. Whether that happens in the majority of the cases, the people I see come in and have all but ignored that information, but so be it. You know, there are a lot of cases that I wouldn't see where I'm making an assumption, and maybe you know better than I do, that maybe it prompted them to pick up the phone and say, you know, I can pay, but I'm out of work, and this is what I can pay, and this is why I can only pay that amount. So, so we send them that notice. We try to encourage payment or resolution between the parties. If not, they come to a hearing, and at the hearing, one of a couple things happen. Either they informally resolve it, but now they're in the court because counsel speaks to them or a mediator assists them, or they end up coming before me, and then I have a more detailed discussion, and I'm authorized to make an order that is based on their ability to pay. And if in those few occasions where somebody is adamant that they're not paying, no matter what you say, I can refer them to a judge who would then have the authority to get tougher with them, perhaps even commit them, assuming there'd been a valid order to pay. So basically that's what's happening at the payment review.
I think people that go into small claims court don't understand necessarily that there's a possibility that they could actually be held for a period of time until the bill is paid, because we keep talking about there's no such thing as debtors courts anymore, which is true, there isn't.
There isn't.
But that hasn't changed the law and the authority of a judge, so.
No, and there are, and as I understand it, it's basically a contempt hearing. And there's a couple
Correct.
ways you can go with contempt. It can be more criminal in nature, where we're going to punish you because you didn't do something, or it can be coercive, where we're going to put you in jail and you can purge yourself of contempt by paying money. You know, I have to say that we rarely put people in jail.
That's
The occasions that somebody is threatened with that or actually put into lockup seems to motivate payments. So
rather quickly sometimes.
rather quickly, yeah. And you know, some would argue it's counterproductive, because if they're in jail, they're not making payments. But and there was a case that was decided a couple years ago on contempt, and I think it had to do with a probate matter. But there are rules about contempt that, you know, if you were going to find them in contempt and really put them in jail, you'd probably have to afford them, them being the defendant, an attorney, and all the procedural rights, because it's a big deal when you put somebody in jail.
Right.
But yes, it exists, and yes, we have sent people to jail. They pretty much come up with the money. And I seem to recall somebody one night getting on the van to go away. And
As the money
as the money arrives. So yes, that does exist.
Okay, what about the other two committees or working groups, one in 2009 and one in 2013, the trial court's access to justice?
The 2009 working group, I was not on that, was driven by, I believe, a perception that debt collectors had become too aggressive. It's interesting to me, and somebody said something to me when I was on the committee in 2001, that the pendulum kind of swings as, you know, society changes. And back in 2001, there was a sense that people don't pay, and we needed to get tougher to get payment. And in 2009, the sense, and I think there were a series of Globe articles that kind of highlighted the excesses and the abuses with collection attorneys and private organizations, that there needed to be more protections for people. So that was a driving force to that committee. And what came out of that were some enhancements to the rules, a large volume of what we see are credit card debt.
Right.
And credit card debt is often sold to several people. And so by the time it hits a small claims, the defendant could fairly say, I don't know who it is
That's
this
suing me.
is.
Right,
And so the rule requires that they give information about the account. They give the name of the person they originally had the debt with, and I believe it's the last 4 digits of the account and the last payment made. And it also requires, there was a rule change to require a verification that this is the address that they're at, because what we also saw was very old debts, credit card cases, where somebody has moved. We become a much more transient society, and people have moved. And so the rules sought to, or the rule changes sought to improve what we're doing by making it more specific. So that people know, and then they can look at it and decide, do I want to defend this or not?
Right. Okay, let's talk a little bit about procedure. It's kind of a 3-part process. So let's talk about filing, first of all, Francine. The various levels and so on and so forth, and the filing fees and what have you that go with that.
The filing fees depend on the amount that you are seeking. And I did not memorize them.
I should have, but I didn't.
I think up to $500 is $40.
I believe.
$500 to $2,000 is $50.
I believe.
2,000 to 4,000
Or
is
five.
$100, or 2,000 to 5,000
5,000 maybe.
is $100, and 5,000
We won't hold you to it because it's
Yeah.
going to change next week
is
anyway.
$150.
I'm kidding. I don't know if it's going to change, but
So that's the filing fee. That gets added on to whatever damages you're seeking. The form is a 3-part carbonless form. It can be typed. We handwrite them. I think most people do. As Wendy had told me before the show started, they are moving towards slowly electronic filing and not
I'm
quite
ever
there
the
yet.
optimist, and I think we will get there someday.
But for now, it's a handwritten form, fairly simple to fill out. You fill out the name of the person suing, who is the plaintiff, the person being sued, who is the defendant, and a general explanation of what the damages are or why the damage is accrued. There's no, what they call fatality. There's no injury done to you if you don't claim everything on the form. So if you don't make a full case on the form, just a general, we entered into a contract for this, they didn't do it, now I have damages of this much money. If you are representing somebody, you do have to put the account number and the date and amount of last payment. There's something called a military affidavit right on the form, which is nice rather than having to fill that out separately, which states the person that you're suing is not in the military, because you cannot get a default judgment against somebody who's in the military.
Or at least in the active.
Active military.
service, yeah.
yeah.
And then you sign it, mail it in with the filing fee, and within a few weeks you get back your court date.
And the nice part about that is that the defendant, if you're the plaintiff, the defendant also gets notice from the court.
Yes.
So that you don't have to get a constable or sheriff to serve it or anything like that. So that's also good. Okay, and then at some point that date comes up and you have a trial. What takes place at the trial?
In trial, the court starts, the first thing is the first call of the list, where the clerk will call all of the cases that are on for that day. Again, if you are the person doing the suing, you're the plaintiff. If you're the person being sued, you're the defendant. You answer when your name is called. If both of you are there, you're given the opportunity to go to mediation, which is available if you want to try to work things out. Or if you're being sued by a lawyer, you certainly have the opportunity to talk to the attorney. In between first and second call is normally a good hour, hour and a quarter. So there's plenty of time to talk, try to work things out, get an agreement to the clerk. If you're able to reach an agreement, you're one of the first cases called when the magistrate gets on the bench. If you're not able to reach an agreement, then you both stand in front of the magistrate and tell your story. And that's really all there is to it.
As far as assistance, Wendy, in terms of the clerk's office, your office in Ayer, for instance, and I know you can only speak for your office in Ayer, but what sort of assistance could I, as a layperson, expect from your clerks when I'm filling out this form that is foreign to me, number one, and number two, I've never been in court before in my life, so this whole thing is an adventure, to say the least. What sort of assistance am I going to get from you?
Well, and in a word or two, I would say procedural assistance versus legal advice. But as we were discussing prior to airtime, that's a very gray area, and that's a very substantial part of the business that certainly my office staff grapples with every day, because we can tell you what the options are. We can tell you that you can go to small claims. We can't tell you to go to small claims. And I think that what everyone needs to remember is that we're a neutral party. And what we experience an awful lot is that people call or come to court with their problem and want to put us in the position of being an advocate. And they'll try to either talk us into that or take from what we've said that we're somehow an advocate for them. We're not here to advocate one person's position over the other. In fact, we have to be equally receptive to all parties, including the defendant.
Right.
You know, and some plaintiffs find that difficult. So we do spend an awful lot of time hand-holding. There is, and we didn't touch on it, but the most recent trial court initiative was a translation of the 7 or 8 most commonly non-English spoken languages, and
That ought to be fun.
it was a much more It was a bigger project than I
hope
ever
I don't get
envisioned.
one of those someday.
Well, what they did, there was a grant and there was some money, and we had to first agree on what we were going to translate, and then apparently within languages, there's all kinds of disagreement about
Right.
various
dialect.
words and
Sure.
and what is now available on the trial court website, which you can access through mass.gov, is translations of a Q&A. There's a whole bunch of questions and answers, so somebody can go online, and of the most commonly used forms. And the theory is that if we can give you a form in your native language, you can look at it, and then you come in, and by the way, you have to file it in English, so that's
Right.
a separate issue. So,
Right.
so we can provide that kind of assistance. If somebody presents and they have a problem with the language, we can make arrangements for an interpreter. Might not be that moment in time, but we will do that. And if somebody can't write, which happens, we can write, but we would have to be careful that we write what they say, not what we say.
What we think they should say.
So there's a fine line that is often misunderstood in terms of people coming to us because they're seeking something and they want us to get them that something, and probably a lot of the negative comments surround that. You know, I thought I was going to get this, or the court doesn't work, or this didn't happen, or the biggest one, I didn't get my money.
This is not a good decision.
Yeah, yeah. So it's basically the difference between what's procedural advice and giving legal advice.
And I want to point out that neither Wendy nor any of her colleagues in the court systems, clerk magistrates, assistant clerks, and so on, are expected to go into small claims court and give you an emotional judgment. They're supposed to be giving you a legal judgment for the most part. You don't get that in every court because we're not fortunate enough to have lawyers in every court that understand the law. But for the most part, I think if they're not lawyers, they probably get help from other sources in terms of interpreting what they have found. But it is a legal decision regardless.
It is.
And it's not something just totally built on emotion.
It not only
as people would like to think
well,
it
it
is.
is not only is it a legal decision; it has to be based on substantive law. But you, as the plaintiff, have an obligation to prove your case by a preponderance of the evidence,
Right.
which is the standard in any civil case. That's not like reasonable doubt in a criminal case. It's
Right.
much lower. It's, what do they say, 51-49?
Right, exactly.
However, you have an obligation to prove your case. And, it's happened many times that somebody who has a great amount of emotion tells their story but doesn't prove their case. And I'm compelled by law to then enter a finding for the defendant.
Right, right.
And there's no do-overs.
Right,
You can't
right.
come back and say, oh, whoops, I should have introduced this. And
Well, there might be a do-over for the defendant, but we'll talk about
Well,
the
okay,
do-over
okay,
later.
okay,
A
okay.
little bit. You can file in mail or in person. You indicated that, right? I think the most important part of filing a complaint, though, is to understand that the block on the form that you have to write the case and the facts as you see them as to how this other person owes you money should be clear, concise, and brief, because you don't have a lot of room. I mean, it's not like a 10-pager. So you need to be within those parameters. The big question is, where do we file? Because there's different views on that, but you have a recommendation.
Well, I mean, jurisdiction, and I don't want to get overly technical, but jurisdiction, go back to law school, subject matter jurisdiction and personal jurisdiction. So that's the first issue, is subject matter jurisdiction is the authority of the court to hear an action.
Which we'll assume is the case.
We
So
assume it's the
thing
case.
we
So the
have
next
to
thing
worry
within
about-
that is venue, which is what is the right court to be in.
Right.
So the statute right now says you can go to either where the plaintiff lives or the defendant lives. And then there's another thing about rental property, I think, if
And
it's
also
a lit.
where business is.
Or where
for
business.
Either
but
one.
Either one. From our perspective at least, there's a practical problem down the road if, for instance, You live in Westford and you're suing Francine in Harwich. And you come to Ayer because that's easy for you. Now you get over into the collection side, and now it becomes perhaps much more expensive and burdensome
Right.
to have to get her up here to answer this case. So we suggest that people think about that. I mean, a lot of our cases, everybody's within the jurisdiction. So, and I did look at the rule yesterday just to clarify that you can only transfer it when the defendant's moved. That's what the rule says. So if you filed against Francine in Harwich, you might not get the opportunity to move it up here, or move the case from up here down to Harwich. So you
Right.
might be stuck with, for instance, a hefty sheriff's fee if you had to have her arrested and brought up here. So you might want to think about that. I will say, you know, there's some practical considerations. The courts have just been through an extended period of economic downturn. We had a hard hiring freeze, and some offices got hit harder than other offices. So some offices carry bigger backlogs. So you may want to choose
When
a
you
court.
say offices, you mean courts?
Courts, and I'm thinking in terms of clerk's offices, but
Okay,
courts,
yeah,
you
okay.
know. So, I mean, that might be a consideration too.
Okay. The defendant can file an answer, okay? And
But
the
does not
defendant
have to.
doesn't have to, right? And the defendant can also file a counterclaim, or what some people call a countersuit, and can also bring in a third party, which is a rather technical issue, but it means that somebody else is involved in this mess, and their name wasn't on the complaint, so I'm going to call them in because they should be here. So,
They can do
that-
all of that.
what's
And
that?
they can do all of that, and I've sometimes suggested that because in the course of a case, it will come up that, well, I didn't really owe this, they owed it to me, and I'll
Right, right.
suspend and say, I'm going to give you permission to bring that person in.
Yeah,
So
right.
we can do it all at the same time. But yes, they can do all those things.
We see that a lot with debts that were the subject of a divorce,
Yes.
where
yes,
one
that's
party
place.
contracts,
yes,
but according
yes.
to the separation agreement for the party's divorce, the other party was responsible for it. So
Right.
there's a third-party defendant.
Right, right. Okay, well, again, this is the sort of the end of part one of this show, and we're going to be bringing you part two. Don't hold it against us for having the same clothes on, because we're going to shoot it right after this one, and we do have other clothes. But anyway, I want to thank you all for watching, and I hope that you get to see part two as well, because I think the two put together is going to be more of a puzzle solver for you. Again, thanks for watching, and thanks to two of you for being on.
You're welcome.